Section 139, Examination of Non-Witness. Section 139 of Evidence Act 1872 speaks about cross-examination of a person called to produce a document. This section says that no cross-examination of such person who was summoned to produce a document. Apart from witnesses' testimonies, there are numerous other forms of evidence admissible in the court of law. Documentary evidence, as described in Evidence Act, is one of them. A person might be called just in order to produce a document. Section 139 says that such a person called in for producing a document does not become a witness, but he cannot be cross-examined unless he has been called as a witness. Under Section 140, Witness to Character. Section 140 of the Indian Evidence Act 1872 speaks about witness to character. This section says that the person who gives the testimony regarding the character of a person may be cross-examined and re-examined. The act of causing something to move up and down with quick movements as is credit. The character evidence helps the court to estimate the value of evidence given against the accused in a criminal cases. Under Section 141, Leading Questions. Section 141 of the Evidence Act 1872 defines the term leading questions. These sections define leading questions as any question suggesting answer which the person putting it wishes or expert to receive. A leading question is that which signals to the witnesses the real or obliged fact which the prosecutor expects and desires to have confirmed by the answers leading to questions. In other words, question is a leading one when it points to witnesses the real or obliged fact which the examiner expects and desires to be confirmed by the answer. The circumstances in which the questions arise determine whether a question is a leading or not. Leading questions can be very dangerous because they can be formulated in a way which slants results, and the same holds true for leading questions used in a media interviews. Under Section 142, when the leading questions must not be asked. Section 142, when leading question must not be asked. Section 142 of the Indian Evidence Act 1872 speaks about when they must not be asked. This section says that the leading question should not be asked in examination in chief or re-examination if they are objected to. The court may give the permission of a leading question to pull the attention of the witnesses, which cannot otherwise be called to matter under inquiry, trial, and investigation. The witness must report for what he himself had seen. This section provides the exception to the general rule stated above. By the order of the court, examiner may put a leading question in examination in chief or re-examination as to matters which are unchallenged the matters in which the opinion of the court have already been proved. The court can allow a party examining his own witness to put a leading questions by way of cross-examination. These are exception under section 154 of the Evidence Act. Under section 143, when leading question must be asked. Section 143 of the Indian Evidence Act 1872 speaks about when they must be asked. This section says that the leading questions can be freely asked in a cross-examination. The reason why leading questions are allowed to be put to an adverse witness in a cross-examination is that the purpose of cross-examination being to test the accuracy, credibility, and the general value of the evidence given, and to sift the facts already stated by the witnesses. It sometimes becomes necessary for a party to put leading questions in order to elicit facts in a support of his case, even though the facts so elicited may be entirely unconnected with facts testified to in an examination in chief. Under section 144, evidence has to matter in a writing. Section 144 of the Indian Evidence Act 1872 speaks about evidence as to matters in writing. This section enables the parties to a case to apply section 91 and section 92. This section is meant to be read along with those two sections. This section refers to both cross-examination and re-examination. This section says that any witness who is about to give evidence has to give evidence as to contract, grant, or other disposition of property may be asked whether it was not in writing, and if he says that it was, the opposite party may object to such oral evidence being given until the original document is produced, or until the party producing the witness is entitled to give secondary evidence of it. An explanation appended to the section says that a witness may give a oral evidence of a statement made by other persons about the content of a document, if such statements are themselves relevant facts. Under section 145, cross-examination of a previous statements. Section 145 of the Indian Evidence Act 1872 speaks about cross-examination as to previous statement in writing. This section lays down the procedure by which a witness may in a cross-examination be contradicted by his previous statement in writing or reduced into writing. A witness may be asked in a cross-examination whether he made a previous statement in writing relating to relevant to the matter in issue, different from his present statement, without such writing being shown to him or proved. But if it is intended to contradict him by the writing, his attention must be drawn to it. It is to be noted that a previous statement used to contradict a witness does not become substantive evidence. The only purpose to contradict with the previous statement is to prove that the statement made in the court is not reliable. This section provides for one of the method mentioned in section 138, 140 and 146 to 148 and 153 to 155, in which the credit of a witness may be impeached. The object of the provision is either to test the memory of a witness or to contradict him by previous written statement. Further, the witness is given a chance of explaining or reconciling his statement before the contradiction can be used as evidence by calling his attention to those written part. It is essential to fair play and fair dealing with the witnesses. Section 145 is not attracted in a case of admission. Admission, duly proved, are admissible evidence, irrespective of whether the party making them appeared in a witness box or not, and whether that party, when appearing as a witness, was confronted with those statements in a case he made a statement contrary to those admissions. In a criminal case, evidence recorded can be used to contradict under Section 145. Section 162 of a CRPC imposes bar on the use of any statement made by any person to a police officer in the course of investigation, except for the purpose of contradicting the witness under Section 145. For example, the statement in the FIR made by the witness can be used. Section 146, lawful questions. Section 146 of the Indian Evidence Act 1872 speaks about lawful questions in a cross-examination. This section says that when a witness is cross-examined, he may, in addition to the question herein before mentioned, to be asked any question which is given to test his veracity or a truth. Testing the veracity of a witness means ascertaining his honesty as to the advice of the court, to what extent the witness is creditworthy. A witness may always be subjected to a strict cross-examination as a test of his veracity or accuracy, his understanding, his integrity, his biases, and his basis and his means of judging. To find out who he is and what is his position in life. Question can also be asked to find out his position of life, that is, who he is, what he does, what is his source of livelihood, or whether he is genuine or a professional witness. It is common practice to make inquiry into the relationship of the witness with the party on whose behalf he is called a business, social, or family, and also to inquire as to his feeling toward the party against whom his testimony being given. To seek his credit by injuring his character while criminate him or might expose him to punishment or forfeiture. Seeking the credit of a witness by injuring his character means to expose his respectability, that is, whether he is a respectable man and whether his character and conduct are such that he can be trusted to tell the truth to the court. This kind of questioning of a witness is known as cross-examination as to credit. However, questions should not be directed towards laying bare with the private life of a witness. The credit of a witness can be said to have been taken only if it can be shown that he is not a man of veracity and not that he is a bad moral character. However, the section does not permit to adduce any evidence or ask any question in cross-examination that may include the victim's moral character or previous sexual experience with any person. The words in section 146, in addition to the question herein before mentioned, to have reference to the second para of section 138, which is the examination and cross-examination of a witness must relate to relevant fact. Under section 147, when a witness to be compelled to answer Under Section 147 of the Indian Evidence Act of 1872 speaks about when a witness to be compelled to answer. This section says that if any question related to a relevant issue of the case, then Section 132 shall be applicable. Section 132 says that a witness will have to answer the question notwithstanding that the answer may criminate him. Section 147 Evidence Act empowers a court to compel a witness to rely to relevant questions, and if followed, therefore, if he refuses to answer a question, immediate action should be taken against him in the interest of a fair trial. If the court fails in its duty, it hampers the course of justice and brings the tribunal into disrepute. Except in a cases where a witness is protected by public policy or some kind of privilege, or where oral evidence is excluded by extraordinary, by the documentary, excluded by documentary, a witness is compellable to answer any question that is put to him at cross-examination. All cross-examination must be relevant to the issue or to the witness credit. Section 148 to Section 152 are enacted to protect the witness from improper cross-examination.